Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Today I'm looking at an excellent book from Edward Elgar. It's part of the Research Handbooks in European Law series of titles which Elgar have produced. This one is the Research Handbook on European Union Public Procurement Law. It's been edited by Christopher Bovis with a range of contributors. It's available as an Elgar online book as well as in the published form here, and you can obviously obtain it by going through onto the website, and I'll show you the links to that in a moment. Now, Elizabeth and I have talked about this book, and we have come up with a title for our book review as follows: The Multiple Dimensions of Public Procurement Regulation, Deftly Explained. Professor Bovis and his 17 contributors reviewed this area at a time of massive upheaval in the European Union. And that's really where we are, because this is a difficult time. This book came out early in 2016, and I'm recording this in the summer of 2016, having written a review. Here is the book itself. Blue cover. There we go. You've got the spine there, and you've then got some detail on the back. You've got a quote from a practitioner, in fact an academic. Then you've got details about the book there. The book is a heavy book. It's a hardback, and it runs to something like well over 600 pages. Now, the index is by page numbering, so it's relatively easy to find. It's a detailed index and very helpful to have. And the book itself has useful conclusions at the back. There's plenty of footnoting, but there are very useful conclusions for each of the main chapters. And you see the reference material, the actual bibliographical material, is at the back of each chapter. So you can see it's alphabetic order as well, so you should be able to find everything quite quickly, depending on what you're looking for. There is the front page there, and that's the series, the Research Handbooks in European Law. That's the series of titles published so far by Elgar. This is the information if you want to go online and get the information online. That information is available there, and the codes are given. Now, in the book itself, it's split into various parts, as you can see, and in fact 5 parts and 19 chapters, and then there's a conclusion right at the end. These are the list of contributors. There's not a lot of information about them, but at least some of them will be known to you, and they're very highly qualified people in their own right. Then the preface is well worth reading, because the preface sets out where we're coming to at the moment with this subject. Obviously the actual detail was written in October 2015, so it's a little old, although the book hasn't been out that long. You'll see there's quite a lot of footnoting. Then when you get into the book itself, not paragraph numbering here at all, but you've lots and lots of subheads. Now, what do we think about the book? Because the problem with this book is that we've had some decisions made since the book was published. And so let me start off with that. After the events in the United Kingdom in June 2016, with a decision by the British people to leave the European Union, this book and many of the other research handbooks on European law, which have come to us from Edward Elgar, may possibly have to undergo change in the next few years. It depends really on what the United Kingdom actually does as and when it departs from the European Union, and what form that will take, because at the moment we are hoping, certainly those of us who will remain supporters and those who are now grappling with the information available, we're trying to save as much as of the information which we, or rather the directives and the actual substantive law areas that we were able to create during our time as members of the European Union, because they are positive for Britain. And that is really the fundamental of where we are at the moment. And so it's really it will of course get down to politics eventually and policy, but the point is we do actually need to know what bits we want to save. So we're in, I think, for a particularly unpredictable time on all aspects of what we can call European law and its relevance to the UK. And of course we're looking here at public procurement law, which again is a very substantive area because of the money involved, and one can see that immediately in terms of the sorts of of the way we've done our business in the past, and in fact what we're going to be doing in the future. I think it's a particularly welcome handbook on public procurement at this time, as far as academics, practitioners, scholars and advisors are concerned, as we now reconsider what role the UK will have with its relationship towards Europe and other areas on just about every single matter one can think of. Desperate times indeed for those Remainers as we try to work out, as I said, what's going to happen next. Clearly, I'm recording this in the summer of 2016, and we are looking even now to try to work out what's going to happen from now on. We don't even know when Article 50 will be, of course, triggered. And the other question is what is going to happen specifically to public procurement. And because of the money, the huge sums of money involved, we've got to start looking ahead. So where does this book come in? Well, what I've said before is we must thank Elgar very much for their high quality publications. These are well researched handbooks. The problem Britain has, as the editor, Professor Christopher Bovis says, quote, is that public procurement regulation is a necessary component of the principles of free movement of goods and services, the right of establishment and the prohibition of discrimination of nationality grounds. And he adds, it is also a policy instrument. So the reader can see immediately what a problem Brexit now poses for us here, because the issue, and the one which clearly we will need direction on from a cabinet, Theresa May's cabinet, will be dealing with the free movement of goods and services. And of course that includes people, and it does actually go directly to the single market. Now that's for another day, but at least you can see the implications for this book, which could become historically quite important. It will, of course, as I say, therefore, logically following this, boil down to what happens with the Single European Act of 1986, which Margaret Thatcher signed, and whether that statute is completely repealed or not, as the case may be. The decision has yet to be determined, as I say, because the regulation of public procurement does expose an economic and a legal approach to the integration of public markets in the European Union. And if we're not in it, of course, you know what is going to happen. Good point. Now, the editor writes that the public procurement laws that we have are necessary as a component of the single market, attempting as it does to regulate the public markets of the member states, representing a key priority for the EU, which of course will be without the UK soon. So that where does that leave us? Where does it leave the book and its value to the reader? Well, I think it leaves us in quite a strong position, because we do have the crystallising of a lot of views here, and we will then be able to identify what bits we save and what bits are discarded. I mean, I think it's therefore a strong position for research handbooks, and they of course do make a major contribution to our understanding of EU public procurement regimes. And it is at this time, when it's being implemented by the EU member states, and at the pivotal role that they of course are all going to play for the delivery of the European 2020 growth strategy, which of course we're not really going to be part of, because by that time I would imagine Britain would have exited. But we shall have to wait and see. And also we may all have some form of input, because we are going to have to negotiate markets within Europe, as well as Australia, New Zealand and all the other places that the Brexiteers are suggesting we would find markets. But that of course is for the future. The contributors, of course, with this book have identified that the internal market relies on a simplified regime in the European Union, which will result from procedural efficiencies and from streamlining the application of the substantive rules. The title is rightly described as having comprehensive thematic coverage, and it includes the following areas which I think will be of benefit longer term. Comprehensive thematic coverage including the following: the public procurement regulation, strategic procurement, justiciability in public procurement and competition, and public procurement and public service. Let me conclude by saying we feel that the value of this piece of research will remain highly significant for a long time to come as the negotiators get down to the task of Brexit, and we hope that Bovis and his team are not too disappointed by the decision to depart, as there will be a lot more work for them to do as we pick up the pieces of the decision to leave Europe. Thank you, but it's not goodbye, and I just hope that that is the position. Let me just show you the book finally again. There's the front, there is the spine, and then there is the back. Now, if I open it in the middle, you can see the detail. This is judicial activism and public procurement. You've got paragraph numbering there, quite clearly shown. You've also got the useful footnoting running all the way through. There's a lot of detail in this. You've got certainly you've got paragraph numbering in places. Sometimes it's not as apparent as others, but it does actually help to find things quite quickly. As I indicated, the index is actually on page numbering at the back, and you've got a lot to go with the index. What I did like is you've got conclusions to the main chapter headings. Then you've also got, of course, the contents section, which I'll just remind you of again. I'd like to thank Christopher Bovis and his team. I'll just show you the names of the people again. The contributors there and on the second page there. They've done a huge amount of work on this subject, and we can't do our work without having books of this standard. They really are of a very high quality, and they do help us with the overall debate in terms of our jurisprudence, in this case European law jurisprudence. So thank you to all concerned, and enjoy the book. Let's see what happens in the future. It's going to be fun. Bye bye for now. Bye.